Hello, everyone, and welcome to One Civil Law. For today's case, we have State of Oregon versus Mario Aroli Batolo. In this case, a person was pulled over in a vehicle for a traffic violation. During the traffic stop, the officer asked the person if they could conduct a search for drugs. The person consented. Drugs were found. The person has brought a motion to suppress. He's arguing the officer was not permitted to ask that question, that it was improper because it was improper on the basis of the stop. Somewhat surprisingly to me, the state of Oregon actually has agreed with this argument. They've agreed that consent is not valid because the officer was actually not permitted to ask that question at all. This is a deviation from the standard rule, but it is now the rule in the state of Oregon. So we're going to read what the state of Oregon has to say about this matter as it applies to consent, the Fourth Amendment, and drug seizures during a traffic stop. So let's get started with this. In this criminal case, we consider the constitutionally permissible scope of a traffic stop under the Oregon Constitution. Defendant was lawfully stopped for failing to signal a turn and a lane change. During the stop, while defendant was searching for his registration and proof of insurance, the officer asked him about the presence of guns and drugs in the vehicle and requested consent to search the vehicle. Defendant consented, and during the search, the officer located controlled substances. Defendant contends the officer expanded the permissible scope of the traffic stop when he asked about the contents of the vehicle and requested permission to search it because those inquiries were not related to the purpose of the stop. For the reasons that follow, we agree with the defendant that the trial court erred in denying the motion to suppress, and we reverse the decision of the Court of Appeals. I'm pretty positive that in a prior stream, I have once said consent always works. Apparently, I was wrong. Apparently, sometimes consent is not even enough. Wow. Let's read on. Faulkner of the Beaverton Police Department observed defendant's vehicle changing lanes and turning without signaling. Faulkner initiated a patrol car overhead lights and defendant pulled over. Faulkner approached defendant's vehicle and requested driver's license, registration, and proof of insurance. Defendant was able to immediately produce his license, but spent about 3 to 4 additional minutes searching for the registration and proof of insurance. Faulkner asked defendant about the presence of weapons, drugs, or other illegal items in the vehicle and requested consent to search the vehicle. Defendant responded, "Sure, okay," and consented to the search. During the search, Faulkner located a small package on the floor between the driver's seat and the door. Faulkner examined the package, found it to be consistent with drug packaging, and observed a substance in the package that he believed was methamphetamine. Faulkner placed the defendant under arrest. Don't consent to searches. Always a good tip. Although apparently here it didn't matter. The state charged defendant with possession of methamphetamine. Defendant moved to suppress the evidence because Faulkner had violated his constitutional rights by unlawfully expanding the scope of the search. Faulkner testified that his questioning had been routine inquiry, all the same spiel every time. Every time I walk up, I say, "Hey, Officer Faulkner, Beaverton Police Department." Do my contact with him. I say, "Do you have anything illegal in the drug? Would you consent to a search for guns, drugs, knives, bombs, illegal documents, or anything else you're not allowed to possess?" I have no problem believing that this is a fairly routine question. I question the way it's worded, but I have no problem believing that he asks it in one form or another as routine, because why not? Defendant maintained Faulkner's question went beyond lawful scope of the traffic stop. The trial court disagreed. At the Court of Appeals, defendant argued that Faulkner had unlawfully expanded the scope of the traffic stop by asking investigatory questions that were unrelated to the purpose of the stop without independent constitutional justification. The state responded that the Court of Appeals case law authorizes an officer to request consent to search a vehicle during an unavoidable lull in an investigation, such as where a person is searching for requested documents. The Court of Appeals agreed with the state and affirmed the conviction in a per curiam decision. Defendant petitioned for, and we allowed review. In this court, defendant renews his argument that Faulkner violated his rights when Faulkner asked him questions about drugs and weapons and requested consent to search the vehicle because he proposes that officers' questions or requests for consent to search that expand either the duration or subject matter of the traffic stop are not reasonably related to the purpose of the stop and therefore are impermissible unless the officer has an independent constitutional justification for making such inquiry. So there's two potential factors at play here. There's the time issue and there's the subject matter issue. The U.S. Supreme Court has ruled on the time issue that the officers cannot extend the time of the stop, but can they extend the subject matter of the stop? To the best of my knowledge, the U.S. Supreme Court has not ruled on that issue. And here they're saying, well, all the officer did was extend the subject matter, not the time. So therefore, it was a proper question. That was what the lower court held. But let's see what the court here says. In response, the state contends that questions that are unrelated to the purpose of the stop do not implicate the Constitution unless questioning extends the duration. So here they're arguing it's only improper if it extends duration, not scope. Further, the state argues, when an officer asks questions and requests consent to search a vehicle, it does not amount to a constitutional violation because neither action imposes any additional restraint on liberty. Article 1, Section 9 of the state constitution establishes the right of people to be secure in their person's house, papers, and effects against unreasonable search and seizure. So this is a parallel to the Fourth Amendment, but because it's in the state constitution, the state Supreme Court can interpret this as broader than the United States Constitution. So although the language is very similar, the state Supreme Court has the latitude to interpret it as broader than the United States Constitution's equivalent. This case involves a traffic stop, which falls somewhere in between not okay and okay. This court has recognized that when a motorist is stopped for a traffic infraction, that stop implicates the search and seizure. This court has explained in various circumstances the limit that Article 1, Section 9 places on investigatory activities during a traffic stop. For example, in Rogers versus Kirby, we considered what constitutional limitations, if any, apply to an officer's ability to ask questions unrelated to the purpose of the traffic stop at the end of the stop. We held that police authority to detain motorists dissipates when the investigation reasonably related to that infraction, the identification of persons, and the issuance of the citations is completed or reasonably should have been completed. The difference in that case was the question was asked at the end of the stop, not during the stop. So they're saying it improperly extended the time because your purpose of the stop was complete before you asked the question. That's the factual distinguishment. This court agreed with the state that officers' verbal inquiries are not searches or seizures in and of themselves. We determined, however, that where the show of authority is inherent in a traffic stop, combined with an officer's verbal inquiries, resulted in a restriction of personal freedom that violated our Constitution. In Watson, this court considered the authority of an officer to perform unrelated investigatory activities during a traffic stop. In that case, the defendant was stopped for failing to maintain a lane of traffic, and the officer requested driver's license to verify his driving privileges and to run a check. The officer asked the defendant about community rumors. The defendant was dealing small amounts of marijuana and asked consent to search. The defendant denied the allegations and refused consent. At that point, another officer arrived and reported a strong odor of what he believed to be marijuana emanating from the defendant's vehicle. Just a coincidence, I'm sure. The defendant moved to suppress the evidence, and a trial court denied the motion, and he was convicted. Considering each action individually, we concluded that each action had been reasonably related to the investigation of a traffic stop itself, had not led to the discovery of suppressible evidence, had not extended the stop, or been justified by independent constitutional justification. In reaching that conclusion, we held that, under our Constitution, investigatory activities must be reasonably related to the purpose of the stop. That holding in Watson was subsequently applied to this court's next case that considered the limits on police authority during a traffic stop. We considered whether the Constitution permits a routine weapons inquiry during every stop. We concluded that routine weapons inquiry, absent a specific showing, fell outside the permissible scope of a stop. As the state recognizes, these cases stand for the proposition that there are temporal limits on an officer's authority to make a stop. Therefore, inquiries that unreasonably extend the duration of time of the stop violate our Constitution. Here, the state argues that our decision in Watson, decided after Rogers Kirby, confirms that Article 1, Section 9 imposes only temporal limitations on when an officer who makes a lawful stop may ask unrelated questions. We disagree. We disagree that when a request for consent to search is made during a lawful seizure, that request is not of constitutional significance. As our cases demonstrate, our Constitution limits not only when a stop may be made, but also the purposes for which it's conducted. In sum, we conclude that for the purposes of our Constitution, all investigative activities, including investigative inquiries, conducted during a traffic stop are part of an ongoing seizure and are subject to both subject matter and duration limitations. According, an officer is limited to investigatory inquiries that are reasonably related to the purpose of the traffic stop. That understanding in place, we conclude that Faulkner's questioning and request to search violated our Constitution. Faulkner stopped defendant for failing to use a turn signal, but then inquired about possession of guns or controlled substances. Having concluded the defendant was unlawfully seized in violation of our Constitution, we must determine the effect of that violation on the admissibility of the evidence seized during that search. Generally, evidence will be suppressed if evidence was product of an unconstitutional act. Here, defendants voluntarily consented to search of the vehicle was granted in response to an unlawful line of questioning and request for consent. Here, the state reasonably does not argue in this court and did not argue in the Court of Appeals, the defendant's consent was only tenuously related to the illegal inquiries. Accordingly, the trial court erred in denying defendant's motion to suppress. The decision of the Court of Appeals is reversed. Judgment of the Circuit Court is reversed, and the case is remanded for further proceedings. That is the end of the case of State of Oregon versus Mario Aroli Bertoli. In this case, we learned that a person was stopped during a traffic stop for a routine traffic violation, failing to signal. And during the stop, the person had to search for his own registration and proof of insurance for about 3 to 4 minutes. During this period of time, which was unavoidable, the officer asked, "Do you mind if I search your car?" And the person said, "Yeah, sure." And so with that consent in place, the officer then proceeded to search the car and found drugs. Now, normally, in like any other state, this would be totally fine because you consented to the search. And so the officer didn't extend the duration of the stop. You extended the duration of the stop by giving consent for the stop to be extended during the search. But here, the state of Oregon held that they violated the rules by extending the subject matter of the stop. The purpose of the stop was for the traffic violation. And so you can't ask any questions that are outside that scope. So I would not try this in any other state, but at least in the state of Oregon, apparently consent alone is not enough. So that is the end of this case.